are looking at a really fascinating case today, Arshnoor Singh v. Harpal Kaur. And on the surface, it's this huge family drama.
It really is. You have a father giving away the entire ancestral estate to his second wife.
Just to get her to marry him.
Well,
When you dig into it, this is actually a masterclass on Indian property law.
exactly. It clears up one of the most confusing areas out there. The difference between ancestral and self-acquired property. And the mission for this deep dive is to show you why a date on a death certificate can matter so much more than the date on a deed.
So let's set the stage. There are 4 generations involved here.
Right. It starts with the great-grandfather, Lal Singh, then his son, then the father in our story, Dharam Singh, and finally his son, Arshnoor.
And the conflict really kicks off in 1999.
It does. Dharam Singh, the father, he executes these sale deeds for the family land to his second wife, Harpal Kaur. But, and this is crucial, he later admits no money ever changed hands.
So it was a gift, a condition for the marriage. But when the son, Arshnoor, turns 18, he challenges it, and the High Court actually shuts him down at first.
They did. They argued that because the family had partitioned, divided up the property back in 1964, it wasn't joint family property anymore.
They saw it as the father's individual property to sell as he pleased.
And that brings us to the real aha moment of this whole case. The Supreme Court completely overturned that ruling, and they did it because of one single date.
1951.
1951, the year the great-grandfather, Lal Singh, died.
And why is that so important?
Because he died 5 years before the Hindu Succession Act of 1956 was passed. Since the succession happened before that act, the old law, the Mittakshara law, applies.
Okay, so let's break that down for everyone listening. Under that old Mittakshara law, how does a partition work differently?
Well, this is the nuance the High Court missed. Under Mittakshara, even when you partition property and a father gets his share, that share remains ancestral in his hands when it comes to his own sons.
So just dividing the land doesn't erase the birthright of the next generation?
Not for this specific timeline, no. The moment Arshnoor was born in 1985, he automatically became a co-parsoner.
A joint owner.
A joint owner. The land was his by birth. His father, Dharam, couldn't just treat it like some property he bought himself.
Which means he didn't have the absolute right to just give it away. But, I mean, people sell ancestral land. It happens. You can't just lock it up forever.
That's true. The father acts as the Karta, the manager of the family property. And he can sell, but the law ties his hands with something called legal necessity.
And this is the big takeaway for any property buyers out there. Legal necessity isn't some vague idea. It's a very strict list.
It is. It's for things like paying off family debts, preventing foreclosure, maybe essential religious ceremonies. The Supreme Court was crystal clear. Pleasing a second wife is not a legal necessity.
And since Dharam admitted he was a sham sale anyway, no money, the whole thing was just void. But what about the other people involved? I saw in the notes that Harpal Kaur, the second wife, she tried to sell the land to others while the case was going on.
Yep. And those buyers were out of luck. The court applied the doctrine of lis pendens.
Which means pending suit.
Right. You just cannot sell property that's in the middle of a court battle. Because Harpal Kaur's title was declared void, any sales she made were automatically canceled too.
That is a huge red flag for anyone looking to buy land.
It is the ultimate buyer beware. The burden of proof is on you, the buyer, to check if a sale of ancestral land is for a valid legal necessity. You can't just take the seller's word for it.
So to wrap this up, the big lesson is that ancestral rights are incredibly strong. A parent's whim can't just extinguish a child's birthright, especially if the property's lineage traces back to before 1956.
It really prioritizes preserving the family legacy over the individual autonomy of the person who currently holds the land.
Which leaves us with a final thought for you to chew on. We live in an age that really champions individual freedom, the right to do what you want with your own assets. Does this strict idea of a birthright still make sense? Or does it unfairly handcuff parents from deciding who they think truly deserves their legacy?
It's a tension between tradition and modern ideas of ownership, and it's not going away.
Something to think about. Thanks for joining us for this deep dive.